It's a real delight to have my co-counsel and Paul Schabas here to talk about the hearing and the issues. We can talk about them in a little bit more depth than might have been possible during the time constraints of the hearing today. And we can take the discussion in different directions with our students and members of the legal profession and the community who are here today. I thought I would start with a very brief introduction to the case for those who aren't familiar with it. I assume since you're here, you are familiar with it, but maybe those who are going to be watching the video recording need a brief introduction. The case concerns the limits, if any, on jurisdiction when content is published solely on the internet in a jurisdiction. The facts were a newspaper article published in print and online by an Israeli paper, Haaretz, and on haaretz.com. The article was about a professional soccer club in Tel Aviv owned by a Canadian-Israeli businessman. And I guess the topic of the article was the subject of some debate.
I'm glad to hear you describe it that way.
Yeah. And in the article, there was either a grenade tossed casually about the plaintiff, Mitch Goldhar's Ontario business, or depending on which judge of the Supreme Court you ask, this was the focus of the entire article. Anyways, the question for the court was whether the fact that this article was downloaded by between 200 and 300 people in Ontario created a real and substantial connection to Ontario such that an action for libel could be brought in Ontario. The corollaries of that were whether the presumption of jurisdiction was rebutted, and whether the motion judge correctly decided not to exercise discretion and rule that Ontario was forum non-convenience. And wound up in all of that was an issue I'd really like to talk more about today, which is what is the applicable law? Is it Israeli law or Ontario law? And how do we choose the law of cyber libel? Is it the classic rule of lex loci delicti or something different, the place of most substantial harm? Before we get into all of those technical issues, I'd like to actually give each of the panelists an opportunity to give their reaction, what you thought the bench thought of the case. And why don't we start with you, Marina?
I was just going to say, maybe we could start with Paul. I think it's really hard to read the bench in terms of the future direction. I think it was clear that they understood the challenges of internet jurisdiction and these kinds of issues that are currently arising. So whether a one-click or one read in a jurisdiction is sufficient to establish real and substantial connection. But past that, I really couldn't read the court in terms of whether they're interested in refashioning Van Breda to take into consideration the internet factors. I think it was a fairly strong message, and I think, Paul, you probably got that too, that they're content with Van Breda as the framework, and that is not necessarily something they're inclined to change. And so I think it's the matter of how do we shoehorn the internet within the Van Breda framework. That at least was my impression. And I think issues that were pertinent to CIPPIC's intervention in terms of access to justice and the impact of technology, I feel confident that the court understood where we were going and that that those issues were important. And I think there were a couple of questions from the bench on access to justice that were really important. And I think it was really interesting to actually talk about access to justice both for plaintiffs and defendants, which is something that we really haven't heard so far. But past that, I don't know, Paul, maybe you have a better sense.
No, I was dodging the spitballs that were being sent my way. I think you're right. I don't think that they're going to mess with the framework that they set up in Van Breda. And I mean, that didn't surprise me. My little twist on it, which I got a rough ride on in the first 10, 15 minutes or so, was to say you should, there shouldn't be a real substantial connection there shouldn't be a presumption if it's over the internet, and they didn't like that at all. But I persevered because I think it is important to emphasize to them that in libel, the idea that the tort is just automatically committed in the location just because it's read there is not a reliable basis. What disappointed me was that I don't think a lot of them are going to even focus on the rebuttable nature of the presumption, which I think is really important. And this was an issue that, while the Court of Appeal all said the presumption's not rebutted, Justice Peppel would have rebutted it, but for, she said, but for the holdings in Banro and Breda, which were these two cases that were decided with Van Breda 5 years ago. She didn't explain why, but she said that she was clearly reluctantly driven there and said it seems to make the rebuttable nature of the presumption illusory. So I'm hopeful that when they go back and they think more about this, they'll think about what it is that makes it rebuttable, which I think they haven't really thought very much about. They said a little bit in Van Breda about it, but I think especially in the context of the internet, they have to think more about it. It's early for me to even reflect on it, but I think you're right. They understand a lot of the technology issues. I think some of the resistance and challenge in the debate was actually more around concepts around defamation law, which, dare I say it, having just argued it in front of the Supreme Court of Canada, but it is not a new experience for me to appear in front of judges who don't know very much about defamation law and have never tried defamation cases and ask questions and say things that are very much plaintiff-oriented around the right to protect your reputation and not appreciating enough the issues of fairness to the speaker and fairness to the media and the role of the defenses. And I think I got a bit of that, frankly. I got a lot of it, I think, from Justice Moldaver, who was talking a lot about, well, he's damaged here, and in not distinguishing the sting from the damage, and not appreciating, or not seeming to appreciate. He just asked me a lot of questions about, what is this trial really going to be about? It's not going to be about calling evidence from anybody in Canada to say his reputation's been damaged here. It's going to be all about justifying the statements in the article, and so it's hard to get people around that. So, we'll see what they do on the choice of law. I don't know. We'll talk more about that.
Yeah, I guess my impressions are similar to what you've heard. I mean, there were three issues that, as the action was framed. What do we do about jurisdiction simpliciter, if anything? What do we do about forum nonconvenience, if anything? These are kind of the core concepts around when a court is seized of jurisdiction or will decline to exercise that jurisdiction. And then thirdly, defamation, this question of, where does the tort occur? Should we change the rule from, what we call a lex loci delicti to a place of most substantial harm from a jurisdictional perspective? On the first two questions, I mean, my takeaway was very similar. I didn't feel like the court was interested in playing around with the jurisdictional test. I very much got the sense of, we've been there, we've done that, this court has had to say what it's going to say about the law on jurisdiction. And now there may be nuances around how it gets applied from case to case, and this may be one of those cases where the internet factors are so lively and very much in play. But they're not going to do, we're not going to see Van Breda all over again, this earthquake shift in how they approach the question. It's going to be very much a straightforward application of Van Breda to these facts. But on the other question, the question of the tort of defamation, we could well see the court do something here. And I didn't get a sense of what. They were asking questions. They were looking for some assistance from all of the litigators in front of the court on how to approach this question. And I didn't, I got to admit, I walked out of the court without really having a good sense of which way they were going to go, or even whether there was kind of any kind of commonality on the bench about that. There were lots of questions, and they were tough questions.
Okay, Paul, I want to talk a bit about this test for jurisdiction simpliciter. You have a number of presumptive connecting factors.
Right.
And in the intervener's factum, we talked about two of them, only one of which I think is probably relevant in this case. We talked about when e-trade constitutes doing business in a jurisdiction. I think it's pretty clear that Haaretz, on any basis, would not be held to be doing business in Ontario.
Right.
Which leaves the only factor to assert jurisdiction simpliciter, the only presumptive connecting factor, being the place of the tort.
Right.
Now, the court, the Chief Justice, Justice Abella, they didn't want to hear you on that issue at all.
No.
But here's my question for you.
It was in my leave application, that's what I said I was going to do.
well, yeah. When it came to the question of choice of law,
yeah,
and the question of choosing between lex loci delicti and place of most substantial harm, they were very interested in what you had to say. So why didn't they appreciate the implications of that discussion, which came at the end, for the initial question of jurisdiction simpliciter? Did you sense that?
I don't have a sense of why they didn't appreciate it. If that's your question. But you're right. I mean, it's like full circle. I mean, the two things I find, when I was mapping out my argument over the last few days, I started with jurisdiction simpliciter and said, this doesn't make sense that the tort is completed here, because the tort can be completed anywhere. It's not a reliable basis. The presumptions are based on things like, where's the tort committed? Where's the contract? Is someone doing business in the jurisdiction? All those things. And there's this, and I said this today, that there's this notion out there, and courts just sort of say it, that the tort of libel is completed where it's read. And I can't find anything back in the 17th century or 18th century or anywhere where anybody sort of discussed why that is so. And I said, and it doesn't make sense in the internet context. It's not a reliable basis, because it can happen anywhere. But when you get to choice of law, there's the problem of the same thing. It's the choice of law is determined where place of the tort. Bingo. Oh, so you can choose your forum and you can choose your law. And the problem with that is that just doesn't make sense. If everything that, for example, the defendant has done is outside the jurisdiction, largely related to, or in our case, I would say pretty well exclusively related to something that's going on in another country, and it raises real concerns for newspapers. Do they have to start thinking about the law everywhere when they write about anything? And the argument, and academics have written about this too, have raised the point that I tried to make, which was actually, if you switch it from the place of the tort to the place of most substantial harm, that's actually trying to balance a bit of the interests. Okay, the plaintiff may be able to choose their forum to sue the Israeli newspaper in Canada, but he's going to have to do it based on Israeli law, so that you're at least giving the Israeli defendant some hook, and also it plays into the forum nonconvenience, and it might be a reason then to move it, because it's not convenient to try a case in Canada if you've got to call experts from another country to tell the judge what the law is. But I think it's two sides of the same coin.
Now, the Chief Justice was very worried about complicating the jurisdiction simpliciter analysis with all of the evidence that would have to be led to deal with this choice of law problem. Yet later, Justice Abella asked the respondent, Mr. McDowell, what more would be needed to actually deal with this substantive question than was on the record. So do you have any thoughts on that? Would it be unduly complicated to get into this most substantial harm issue at the jurisdiction simpliciter stage? Why or why not?
I don't think so. I mean, I've done a lot of these jurisdiction motions. The defendant has to put together some evidence about what they do and why it's all, why there are not sufficient contacts with Canada. The plaintiff has to do a little bit in response. I mean, the argument, and we had a lot of information before the court. The court knows how many downloads there were everywhere, actually. We didn't file it all for the Supreme Court, but we've got the Google Analytics data of everywhere. It was downloaded in the first 8 months after the article. It's not hard to get. We gave our circulation information, where we have subscribers, where we don't have subscribers, like Canada, except on the weekend. I think there were 5. So that's not that hard to do. And the additional thing that I was saying that was lacking here, which has appeared in other similar types of cases, is have the plaintiff say something about why it's harmed them or why it's particularly important for them to be suing here, which, of course, Mr. Goldhar, they didn't file that in this case.
No.
And I said, what's the big deal? Let them file a little more. Conrad Black did. The Banro case they did. It's not hard.
I thought it was interesting that Justice Brown asked whether there was anything on Mr. Goldhar's side of the ledger to indicate that it would be appropriate to bring an action here or fair.
Right. Well,
came up empty on that.
Justice Pepal, the dissenting judge in the Court of Appeal, had a nice line when she said how we pointed out potentially 22 witnesses we were going to call, and he hadn't identified a single one, so she used the sports parlance and called him scoreless.
Marina, can we talk a little bit about access to justice? This is where we started CIPPIC's intervention. And of course, this is a continuation of your work, which was put to the Supreme Court in Duez,
Don't make me blush.
Where we talked about the accommodation that might need to be made in the jurisdiction framework for consumers as a vulnerable group facing an imbalance of negotiating power. How do you think the court took the issue of access to justice in this case?
I was pleasantly surprised that. So when we prepped for the argument that you delivered, we had concerns whether that would be something that the court would actually grasp, and I was surprised actually that it came out even before you started to speak. So I think, which for me is a very positive development, that the court is integrating access to justice to conflict issues, which is something that hasn't really been done before. Up until Duez, that was really not the framework in which conflicts work, right? It was really predictability for the parties versus access to justice. So I think because of the internet and all the cases that are coming before the court where it really affects everybody, that we're not really talking only about business parties, and we're not talking really about only sophisticated parties, but regular people who may be affected, that the court is much more alive. So, and again, I was also very positively, not surprised, but it was a positive reinforcement by Justice Karakatsanis talking about access to justice both for plaintiffs and defendants. And I think in case of Paul's client, there are access to justice issues for the defendant as well. So I think from CIPPIC's perspective, and again, the message that we were trying to convey is that the framework in this case is going to impact a number of other cases which will not have sophisticated business parties and wealthy plaintiffs. It will affect individual people, and we talked about a number of cases, including cyber violence, where this may be a factor. So I'm hopeful that the court understands that whatever reframing or expansion of Van Breda framework in this particular case will actually impact other potential plaintiffs and defendants in the future. So I'm optimistic, but I'm also cautiously optimistic because I really couldn't read them in terms of where they're going to go. And again, the facts of this case are not a typical access to justice issue where you do have sophisticated parties and wealthy plaintiffs as well.
David, do you want to talk a little bit about why CIPPIC is interested in the access to justice issue and how it sees these questions arising?
Yeah, I mean, so we get involved in a number of different cases that have access to justice components to them. Well, I say cases, but really disputes. We get clients coming to us before any kind of litigation is started. And it's always a concern, especially cyberbullying and publication, non-consensual publication of intimate images, those kinds of cases. So it's always a concern to us, that we have remedies that are useful and applicable. And part of that concern in this case is making sure that they do have access to the courts. if you're dealing with foreign jurisdictions or foreign powers, foreign business, foreign defendants, foreign plaintiffs, etc., that these kinds of interests are going to be able to have access to the Canadian courts. The Canadian courts will offer them a remedy, and that gives us a tool. That gives us some leverage in trying to get, even pre-litigation, trying to get some kind of solution that's trying to get what the client needs as quickly as we can. So that largely motivated our involvement on this particular line of arguments.
Okay, I would like to talk a little bit about technological neutrality. That was another theme in CIPPIC submissions. And I thought maybe I would ask you, Paul. Obviously, you didn't have time in reply to either support or refute anything that we'd said about that. So now, with the benefit of some hindsight and some reflection, what did you think of the exchange with Justice Abella on the issue of technological neutrality and how that might relate to either the framework or other substantive issues?
I think my view on it, I think it's really important that you raised it, because I think it highlights the need to properly apply the framework, if you will. Like if they've got this framework, they should apply it, which means that, okay, you've got presumptions, but they're rebuttable presumptions, right? And it's a matter of fairness and balancing that has to come in, both in looking at the rebuttal of balancing interest, and also down the road in the forum nonconvenience. So generally, I think it's really important that was put there. Much as I tried to carve out my own little special exception and failed miserably, or at least I think I failed miserably. I think that's the right way to go.
Well, we certainly tried to make that point that where you have in the internet context jurisdiction in many places, hundreds, maybe thousands of places, and not just in the cyber libel context. We cited to the court the copyright example with ephemeral reproductions giving rise to potential copyright liability everywhere. That you need to temper that with presumptions that are easier to rebut, or judicial discretion that is easier to invoke in that context.
Oh, exactly.
So David, can you talk a little bit about that technological neutrality and maybe situate the arguments in this case with some of the other issues, copyright or other contexts? Yeah,
so technological neutrality is the idea that just because you're using one kind of technology, that you suddenly don't have you just don't automatically satisfy a particular test and get a particular outcome, or the converse, that merely because you're using one technology over another, you're getting a different outcome than you otherwise would have. So our approach here was to ask the court to apply kind of a functional approach to technological neutrality rather than a media neutral approach. And that means taking a look at the technology that's being used and having a good understanding of how it's, of its implications, of actually what's going on with this technology. And why this is particularly important, we thought, was because we looked at the test for jurisdiction from SOCAN and CAPE, a copyright case, which looked at the jurisdiction of the home server, the jurisdiction of any intermediaries, the jurisdiction of the downloading computer, for lack of I can't remember the exact phrase that the court used, and said that those were all potentially connecting factors. The problem with the internet is they're almost neutral, right? Those are the location of equipment is almost a neutral factor now. And in fact, we know in Canada, just the way that our internet or our access to the internet works, that many communications, particularly cross-country communications, but even an email going from Ottawa to Ottawa can get bounced off of a server in another jurisdiction. It can go into the United States. And that's arbitrary, right? That you need a more pragmatic and functional approach to understanding how the technology implicated in a communication is actually affecting a transaction, affecting a communication, affecting the subject matter of litigation. So we tried to offer the court an approach, a technologically neutral approach, a pragmatic and a functional approach to addressing how technology can give rise to connecting factors in a jurisdictional analysis. We in particular didn't want to have one set of tests for one area of law, copyright, and another set of tests for other areas of law whenever the internet is involved. And we've actually had one case that looked at the Van Breda test for assessing jurisdiction and rejected it in favor of the old SOCAN and CAPE test for assessing jurisdiction in copyright cases. And we think that's a bit of a problem. And so we highlighted that for the court and offered what I hope is a promising way to address technological neutrality.
Same question for you, Marina. What do you think of technological neutrality and the court's reaction to it?
You're asking all these hard questions. Again, I think I'm cautiously optimistic that Justice Abella actually asked you the question within the 5 minutes that you had, that you actually got a question. So I think they're thinking about that, but I'm not necessarily sure. Like, I couldn't really gauge what was the direction. I was actually going to ask Paul, given the type of clients that you have, which are usually newspapers, and so if we talk about SOCAN factors, which are really not, they're predictable, but they're really not necessarily good factors.
The location of the server, the location of routers.
So it's really
physical.
physical. So from the perspective of the clients that you normally represent, or usually represent, how does predictability look like? Like, what kind of factors would be the factors over which they would have control, so that they would control the dissemination of information and therefore control a potential exposure?
That's a hard question too. You know, I mean, I act for, I've done a lot of these cases involving foreign newspapers and media organizations, sometimes other organizations that aren't media organizations. I mean, they obviously would like to see issues like where they are, where their servers are, where their technology is as being the driving force. But I think we all recognize that, you know, that where the server is based is, you know, is becoming less and less meaningful. If it's meaningful at all now, you put it, you know, people put everything up in the cloud, wherever that is. Mm-hmm. But you know, for a traditional media organization like Haaretz, which is publishes a newspaper, but also, like most newspapers, puts it online. The real problem is, you know, how and in what circumstances should they expect to be sued somewhere other than where their audience is and their major audience, you know? And the Court of Appeals says, well, they wrote this story about this guy from Canada, so it's perfectly reasonable for them to expect to be sued in Canada. And Haaretz is going, no, this is all about something that's going on in Israel. It's got nothing to do with Canada. And, you know, when they're sort of saying we're supposed to anticipate these things as to when a court's going to, you know, like Justice Moldaver emphasized that one line and say, you know, and I said this, it's like a gotcha line, which is, you know, not fair, I think. You know, that's the problem with these jurisdictional tests, that sort of, especially I think the Canadian one, which starts with these presumptions of jurisdiction. And you know, you see in Australia it doesn't start with a presumption. In England, because of a rash of libel tourism, they've turned the law around to basically say, you know, show us that England is the most appropriate jurisdiction of all, as opposed to starting with presumptions. And that would serve free expression, free press organizations, I think, much better. You know, it didn't come up today, but I guess it might have been mentioned. I think Mr. McDowell mentioned at one point, well, they could geo-block. You know, I mean, newspapers are all publishing every day. They have limited and increasingly limited resources if they can, you know, manage to cling to existence. And you know, to then have that other burden and threat out there. Oh, gee, this is something about a Canadian. We'd better geo-block this from Canada, assuming they can do that, which isn't so easy, I don't think. People say it's easy, but I'm not so convinced. And there are always ways you can find ways around it. That they now have to worry about that, because if that's their thought, then they're just going to block everything and say, well, you know, Why should we send anything anywhere other than to our immediate audience? And that's not good for the internet.
I don't think it's good for media companies in
No.
particular. This is a model that you see adopted with Netflix, for
Right.
example, but
Mhm.
it's about not having the rights to transmit
Yeah.
content into
Mhm.
that jurisdiction.
Right. Yeah.
So they're in essence geofencing themselves in
Right.
as opposed to their customers out,
Yeah.
which I think is a material difference.
Mhm.
Justice Abella asked about the topic of technological neutrality. What would substantive technological neutrality mean for the issue of substantial harm? And it wasn't clear to me whether she was asking about the jurisdictional framework or the substantive choice of law question. And I tried to give her some insights into both. But what do you think, Paul? What would you have said to that question? What does this principle of technological neutrality mean
I have no idea.
to the issue of substantive harm?
Well, I mean, I'm not sure that they're related. I mean, are they related? I mean, if there's technological neutrality, isn't the substantial harm something different than that? I don't know.
Well, I
What
think
did you say?
Well, I tried to suggest that
You've thought about this a lot more than I have.
Well, I initially interpreted her question about the implications for the jurisdictional framework.
Mhm.
And so I think that this issue of technological neutrality suggests that we ought to apply the same framework, but potentially apply it differently, because the technology itself, as you pointed out, it is not neutral. So we apply the same framework, but we nuance it. Not a new framework, but a
Right.
nuanced framework. But I think what she was really getting at now in hindsight was whether, and if so, how, the principle of technological neutrality favors either lex loci delicti or the place of most substantial harm in a choice of law analysis. I think that's maybe what she was getting at. And on that, I think, like you, Paul, I'm not sure it is closely related.
Mhm.
Although the High Court of Australia discussed that as one of the factors in Gutnick.
Right.
David, what do you think of that question? I was passing notes to you, asking what's CIPPIC's position on this.
Yeah, I think my initial response was, yeah, that wasn't in our factum.
I looked over to my junior when that question was asked. What's our answer to that?
It was, I mean, I guess I won't. It's funny. I was very much thinking about our answer to that question from a results-oriented perspective, right? We always want to make sure that, our primary argument in this intervention was making sure that access to justice factors into the court's analysis, right? That it's not just, what do you call it, the Sport of Kings, defamation of the Sport of Kings. It's not just the wealthy that will be affected by the jurisdictional approach that the court adopts in this case. It will also be, the plaintiffs that we had in mind, which is the kind of the cyber violence issues and the cyberbullying issues. We wanted to make sure that they're in place, but at the same time, we also don't want to see Canada be a place where you automatically get jurisdiction, where because of certain juridical advantages, it's all of a sudden incredibly advantageous to come to Canada with every, for example, copyright file sharing case, because you can automatically get an Equistec order which shuts the business down worldwide until the defendant goes to California and gets an order addressing the Canadian order. So that was, my response was we wanted to suck and blow at the same time. We wanted to make sure that our access to justice considerations were in place, while at the same time ensuring that, kind of foreign shopping considerations, involving technological approaches, are able to be addressed by the court in its analysis. So I don't have a quick and easy answer to the question. It's a tough question.
Can I just resign? I don't know how much the students know about how the place of most substantial harm test was, I would say, to put it nicely, distorted in this case, and I wonder how much that contributed to the argument actually that we were having, because what Goldhar did when we first argued the case was literally right in the middle of the argument. I think it was literally in the middle of the argument. It might have been immediately before, but his lawyer said he's only going to seek damages for the damage he suffered in Ontario, and that was picked up on by the courts below in the most substantial harm thing. Well, we don't need to get into whether it's lex loci delicti or most substantial harm, because he's limited his damages to here, which I said today, well, that sort of amounts to a veto on assessing most substantial harm, because he's taking out the harm anywhere else. And, you know, he might be entitled to do that if he pleaded it properly and limited it in various ways, as, for example, Gutnick did, or maybe Conrad Black did, but I think Gutnick did it more than they did. But what I said was that it's just he's doing a law for the rich, right? Because hardly anybody's read it here. So really, he's not suing over damages. He's just suing in a place where he can make life difficult for this Israeli newspaper and is shutting them up, which he's done for the last 5 years. You know, they're not writing anything about him because they'll you know, a case like this could literally bankrupt the paper. That's how newspapers are. It's not a great big paper. Even if it was a big paper, you know, I act for the biggest paper in the country. They are very wary of libel suits these days because of the cost associated with them. And so I wonder if some of that discussion was kind of weirdly influenced today by the fact that we were having this bizarre discussion when it's so obvious that all of the harm occurred in Israel and not here.
To everyone except perhaps Justice Moldaver.
Right.
About to say.
Yeah. Right.
On the framing of the fact.
Right. Yeah.
I'm glad you brought this up, this undertaking. I made the point that an undertaking not to seek damages outside of Ontario does nothing to avoid multiple proceedings or conflicts of laws or recognition and enforcement of foreign judgment problems. Contrary,
unless you promised, like Black, not to sue anywhere else.
Yes. So
which he didn't.
So,
Goldhar did
so
not
to claim
do.
damages only in one jurisdiction is different from bringing
Yeah.
action only in one jurisdiction. But I hadn't realized that your point is that he may have made that undertaking not in respect of the multiple proceedings, conflicting judgments, enforcement issue, a forum nonconvenience factor, but to circumvent the most substantial harm analysis.
Well, I mean, that's what it amounted to, right? That's the effect of it. I mean, he did it he did it to sort of say that this is why Ontario is important. I'm only seeking damage in Ontario. It's about vindicating my reputation here. But it did have the other effect of distorting the choice of law.
Marina, any comments on this undertaking issue and in the general conflicts in jurisprudence?
So we've only seen it recently in Black's case and in this one, right? And I found it interesting that they said, well, we wanted to mimic what was in Black's case, but we really didn't do it properly.
That was there. Every time we appear, the undertaking's a little bit different. I tease them about that, you know, because it is. I mean, the Court of Appeal described them as on-the-fly undertakings, and they are. And we just saw them on the fly today on it too. You know, they could have, you know, they might have done it a little more clearly at an earlier stage.
But I just wanted to raise something. So we talked about technological neutrality, but I wanted to touch a little bit on that in these kinds of cases, there is really no neutral forum. So it's either the plaintiff's forum or the defendant's forum. There is really no neutral forum, a third country or third place, right? Or where it would be in the middle and it would be equally inconvenient for both parties to go to that particular place. So the starting point has to favor one side or the other, right? Like the initial presumption or whatever the initial test we do has to favor one side or the other. And so, Paul, you were talking about that the presumption of the place of tort heavily favors, in libel cases, then plaintiffs because they claim that it is their own jurisdiction.
Right.
But I'm worried if we flip it or make it easier to rebut, then other kinds of cases that, again, CIPPIC is more concerned about of cyber violence would make it very difficult for local plaintiffs to actually commence actions in the jurisdiction where their legitimate interests lie and where their reputation or other damage occurred. So how do we strike the balance without unduly inconveniencing foreign parties, but also ensuring that local plaintiffs always, or at least in most cases, have access to the domestic court?
Well, I think in a number of these cases in the past, the courts have looked and said the plaintiff is, entitled to, and they, the other side emphasized this. Julian Porter at the end was talking about the value of reputation and the importance of being able to vindicate your reputation. And that's always been a troubling thing in a lot of these cases because Goldhar is not a Libel tourist. He actually lives in Canada. Mm-hmm. And so there's a value in that I think we all recognize. And, if you get into other kinds of cyber violence and revenge porn and things like that, it's very important that the plaintiff have access to that. And I think, again, the cases will be driven by their facts. In Goldhar's case, it's all about a guy who went somewhere else to do something, and it's not unfair to him. But if it's a case of cyberbullying and so on, and you got a kid in Ottawa who's the victim of someone who's doing things to them in Nova Scotia, but there's a number of things there. There's the issue of the victim doesn't have any connection to Nova Scotia. The Nova Scotian person who's doing it is targeting that person, targeting what their conduct, which is in Ontario, and so on. So, we didn't get into targeting very much today, very little actually. But that's that's the dominant sort of element that they use in the U.S. on these issues. Is their targeting? Are they really? Is the defendant focusing on attacking that person in the foreign jurisdiction where that person may be resident? The English are looking at that now in the commentaries. They have commentaries to their new Defamation Act. They talk about one of the factors in considering the most appropriate places is was there targeting to it, and I think that makes some sense. It's not ideal. But it ought to be a factor. I think that would help overcome the unfairness that you're quite right about for the person who has no connection. The odd thing about this case is that he's got a huge connection to Israel, right?
That's one. The facts are unique, I think, and we talked about that as well. That he does have reputation and connections in both jurisdictions, not necessarily at the same level, but
different reputations as well. Reputations for doing different things.
Well, there's no evidence of any sort of public reputation he has at all on the record. That's the interesting thing. And I said I'd never heard of Mitch Goldhar before I got retained. And then I started saying, "You've heard of Mitch Goldhar?" And some people said, "That name rings a bell." And some people said, "No." He's become a little more prominent in the last few years, interestingly, long after he sued. He wants to build a 70-story tower at the end of the new Yonge University subway line in Vaughan. So he's doing more property development. But you don't hear much else about him. But in Israel, he's a celebrity, and deliberately so. Because he's like the George Steinbrenner of, you don't know who that guy is either. They're too young. But
Harold Ballard.
They don't even know who Harold Ballard is.
I want to give a chance to our students to ask questions, particularly those who are at the hearing or those who watched it on the webcast or even those who didn't. Do you have questions for Professor Pavlovic or Fiora? Okay, go ahead.
Well, there was no evidence of what his reputation was in Canada. In libel law, you're presumed to have a good reputation. You don't have to call any evidence of damage. Damage is presumed. If they can prove you said something bad, the defendant can't prove one of the defenses, you're entitled to damages without any evidence. Damages are at large. But what I said that came, and it's pretty clear from Banro and some of the other cases, and Breda and Paulson and others in these jurisdiction cases, was they said that the plaintiff should put forward some evidence, not about damage and the scope of damage, but about what the nature of the reputation is in the country that makes it important for them to be able to sue in Canada. He may, and I always come back to the original test, right? The Van Breda test, the Morgard, the Hunt test, all the way back, is there a real and substantial connection between the subject matter of the action and the jurisdiction? And of course, Justice Moldaver and I did not see eye to eye on this, and maybe not Justice Rowe either. They said the subject matter of the action is the damage to his reputation. And yet, there's no evidence about the damage to his reputation. You're not even allowed to call evidence as to what you think the words mean in a libel case. That is not admissible. What the words mean is for the jury or the trier of fact, if it's a judge, if it's not a jury. What the subject matter of a libel action is the defenses. That's what it's all about. A plaintiff at a libel trial can stand up and testify for 5 minutes. They can probably not even do that. I'm waiting for it's one of my nightmares every time I'm getting ready for a trial. What if they try that? Because I think I would do that. Say, Your Honor, I'm not calling any evidence. I just want to do a few read-ins, and I'll save anything I need for reply. Here's my read-in. They published this article. Read this article. It's a horrible article. It says my guy's a megalomaniac. That's a bad thing. Okay, over to you, defendants. What are your defenses? That's all a plaintiff has to do, is prove publication and of something that is clearly negative of somebody. And then the whole case, so the subject matter of the action then is framed as, are the words true? Are the words fair comment or honest opinion based on facts that are provable? Is there a qualified privilege defense, or did the defendant act responsibly on a matter of public interest? So it's all on the defendant's side of the equation. So to say he's got two different reputations, I'm not sure that really informs that much the jurisdiction, other than for the person, the plaintiff, who's trying to say why they should be in the jurisdiction they prefer. Give us a good reason. Is the case really going to be about that or not?
Paul, there was a lot of conversation this morning at the court.
I wish I'd said that this morning.
Yeah, that's good. I'm convinced.
Someone will pass it on, won't they?
We'll see if we can get the judges to watch the webcast. There was a lot of conversation about what's the trial going to be about, But correct me if I'm wrong, but I don't think it was ever explicitly acknowledged that there may not be a trial. Oftentimes these issues are just decided at the jurisdiction stage, and if it helps, we can abstract from this particular case. But how do you think that factors into it? That the jurisdiction is the trial in many situations.
Well, it is if they decline jurisdiction, for sure. And if you're right, if they go the other way, there may well be a settlement. The Conrad Black case settled not really about the libel case, but about all the other stuff. And a lot of these other cases, they then do settle. This case was brought in 2011, and so it's 6 years old. So will there ever be a trial? For my client's sake, I sure hope not, because that will pose a really difficult challenge for Haaretz, I can tell you, as a small newspaper in Israel, saying, what do we do here? We don't want to spend hundreds of thousands of dollars litigating this case halfway across the world. But on the other hand, they're a principled paper. They don't really want to do a groveling apology to him.
Is there a limitations period in Israel?
Probably. I think there is. I can't remember what it is. They may or may not be beyond it.
Article's still up, though, right?
Yep. Never took it down.
And every new download, I guess, constitutes.
That's no, not in Ontario. Once it became known to him, then he had to serve his notice and move forward with the action. There's a recent Court of Appeal case on that, but you know, the fact that they haven't taken it down and the fact that there may be people who are continuing to look at it would be a factor in damages, for sure.
Any other
Say-
questions?
Just really two quick questions. What do you think the effects are, like in terms of like your comment you just made, on how it might show media, like we've seen with other small media organizations in the U.S. and elsewhere? Do you see that maybe this judgment influencing that in any way? And the second one is just touching on the point of the public figure argument that was briefly brought up, and how you think that that would pan out if the case were to be brought to trial.
So, sorry, your first point again was the chill. Well, you know, I think there is chill. I mean, I see that. I know from Haaretz, you know, my client, that they're wary of writing about Mitch Goldhar anymore. They don't want to face another lawsuit, and I think you know, media worry increasingly about lawsuits, and you know, even big media. I mean, I do work from time to time for the big international media, the Associated Press, the New York Times. You know, they worry a lot about international distribution and downloading over the internet. You know, these lawyers in New York who call me and they say, Canada's still there. So that's like England, right? That's like where, you know, we got to be really careful, right? You know, so it does have that a chilling impact.
Do you see that having like that kind of, like do you see this case being brought for a reason similar to maybe like what happened with Goldhar, like maybe have this as a case where it's a case of attrition, so that the media
I said so, yeah. I mean,
might not be able to talk
yeah, this came up. I briefly talked a little. I mentioned a little bit about slap laws. I mean, I've been saying all along this is a slap suit, and if the legislation had come in earlier, I probably would have brought a motion. I might have done that instead of fight the jurisdiction and brought a slap motion, which, you know, because that's what I think this is. I don't think there's any question. Look, I mean, look at the guy's got so much money. He's not doing this for the money. He's doing it to shut people up. And Justice Peppel seemed to agree, because a couple of places in her judgment, she talks about the competing theory, you know, that he's just spending money and just doing this to beat them down. And you know, he's not the first guy to do that, that's for sure. So, you know, the other thing around public figure and public interest, which I tried to bring them back on track on, to my mind, in my reply, was that, you know, the fact that it's not we don't have a public figure defense in Canada. That's an American concept, this notion of public figure. People sort of go down the rabbit hole here a bit sometimes on that. The issue in the defenses is public interest, and, you know, is a matter of public interest, and that's crucial to some of the defenses. Well, Goldhar's management of Maccabi Tel Aviv is clearly of no public interest in Canada. Nobody picked up the story and wrote about it. Nobody seems to care about it. And in fact, the evidence was that, you know, nobody follows the Israeli Soccer League other than occasionally when they play in an international tournament. You know, I mean, I was told that, you know, everybody's passionate about it in Israel, but it's really a pretty lousy league, I was told. So if it's public interest, you know, that ought to weigh in favor of holding it in Israel, because otherwise we have to, you know, we will, if I've got to try this case here, I'll have to call witnesses to talk about why this is a matter of public interest in Israel.
Okay, we'll take a couple more questions from students. Maybe take 2 or 3 at once, and then Professor Pavlovic has a question as well. So, yeah, you had your hand up, right?
Yeah, my question would be more direct discussion. We discussed slap suits just came up, and I'm pretty curious what the interaction between, I guess, the slap suit framework versus the libel, because I had no idea, but as you mentioned it, in libel law, the framework is very favorable to the plaintiff. And my understanding is that the new slap suit framework, of course, are more there's also more conservative protecting defendants. So I mean, interaction between those two approaches.
Well, there's no question our libel laws are plaintiff friendly. They've become a little less so in the last few years, thanks to the development of responsible communication defense, the clarification of the fair comment defense in WIC. But they are, it's still relatively plaintiff friendly, as I said, in even the process of proving liable, the burden is on the defendant at pretty well every stage. The SLAP law that has just come in is, I think, long overdue and something that helps in some cases to shift the balance, where if the defendant shows that it's a matter of public interest, then the burden switches to the plaintiff at the first stage to show why the action should proceed, including showing some kind of, I forget the exact phrase around sufficient damage, or it's not serious harm, that's the phrase in England, but it's a similar phrase in our SLAP law, which so they've got to address something about the merits of the case and the harm they've suffered, and it's not really shifting the law in principle, but it's giving defendants a way to get out of things where they're just going to be burdened by a long lawsuit. I mean, I have done many lawsuits from plaintiffs with deep pockets who will just want to beat you down through the litigation process, but at the end of the day, they have no intention to take it to trial. They're just costing you a lot of money and a lot of grief because they can. And this is a safeguard against that.
Marina.
So, Paul, I had two practical questions given the questions that I get in class, and I teach conflicts of laws. So my position is always fight the jurisdiction first, because if you win on that one, there is really no action. But in a case like this, where the fighting jurisdiction has been going on for 6 years now, and if you lose, let's assume there might be a trial. So the risk is obviously there. How do you calculate the risk in terms of how far do you go? Or is it always beneficial as a defendant to fight jurisdiction because you may actually kill the case?
It's not, I mean, I would only recommend a client do it where I think they've got a chance of winning. There have been lots of cases where we've talked about it, and I tell them, I think you're going to lose. I think this was a case where I thought there was a reasonable chance of success, and because it's a knockout blow if you win, they said, let's do it. There's also, it's funny in libel cases too. Sometimes time takes its toll, and the plaintiff gets tired. Says, "Oh, it was so many years ago. Do I really want to revisit it?" And they get tired and go away too. It doesn't sound like Mitch Goldhar is that kind of a guy, but look, I would tell a client, you don't bring these just for fun, just as a stalling tactic, because you get dinged with costs too. I mean, my client is facing cost awards, heavy cost awards, from the Superior Court and the Court of Appeal. I mean, we haven't paid them, but if we lose, we've got to pay them. If we win, they'll pay us. It still won't cover anywhere close to the real costs of the motions. So it's expensive, and so there's a whole bunch of reasons why I wouldn't just do it in any case.
Thank you.
Okay, any last words, David, to reflect on the case?
Betting?
Betting. Yeah,
Split decision.
yeah,
For sure.
This is a tough one to call. I mean, it really is a tough one to call.
All right, I'll go out on a limb and I'll start here.
Yeah.
Wagner, Brown, Gascon, and McLaughlin. Abella and Karakatsanis concurring. Moldaver, Rowe, and Cote dissenting. Appeal allowed.
Sounds good to me. All I care about is those last two words. That's not bad. I think, Moldaver, Rowe, and Cote?
Dissenting.
Really, you thought Cote? I thought Cote was pretty, that's interesting. See, you just can't read them. I thought Cote and Wagner were very skeptical of the whole particularly about deference and you know how the judges had approached this from Goldhar's standpoint.
Well, if it's any consolation, I've got her name crossed out twice here on my
Okay.
list. So just moving back and forth from column to column.
Well, that's because she dissents a lot too, right?
The one thing I would say is it was a very interesting panel in the sense that every judge was engaged. I mean, there were questions from every single
Everybody.
judge.
Yeah, that's a good
I
point.
know. I thought about that when I sat down. I looked, you know, you always sort of look up and go, who did I talk to today? And I said I talked to all of them.
Yeah.
And that's always fun. Yeah. You know, there was a moment about 6-7 weeks ago. We got this notice from the court that our appeal date was changed
Mhm.
to a date earlier in November when Will and I couldn't do it. So we had this funny little dance with the court trying to cajole. And then they said, oh, we're going to put it off to January. And I called Will McDowell, and you kind of figured Will and Julie and I are all very good friends, you know. And shit, they want to put it off to January. I don't want to put it off that long. He says, well, why not? What the hell? Go to I said, no, I'll lose the Chief Justice. I want her. And they said, oh, yeah, too bad, Paul. Because she's usually quite friendly to free speech issues. Well, we'll see. You know, so Sheila Martin. Maybe I should have waited till January, but I won't know for many months.
Well, I told my property law students whose class I canceled this morning I wasn't consulted on the matter. So
Yeah,
the
okay.
class canceled at the University of Ottawa. Marina, any last comments before we wrap the panel up?
No, it was fun. And Paul, thank you for sharing it really candid observations. And
My
I think
pleasure.
students really benefited from having sort of seen the whole picture.
Yeah, let me echo that. Real pleasure to have you here at the University of Ottawa. Thanks to Florian and the Center for Law, Technology and Society for organizing this event. And thanks very much to Adam Solomon and Laura Hamilton, two of our University of Ottawa students who worked very hard on this case for many months and right up to the 11th hour, getting that condensed book prepared. It's a great opportunity. We really appreciate it, Adam and Laura.
Yeah,
Thank
the
you.
factum was excellent. Your factum.
Thank you. All right.
Okay.
Please join me in thanking our panelists.